Hello, everybody. It's the 11th of February, 2026. Today, we're going to talk about injunctions are an effective way to prevent support and income withholding orders. Okay, so you received a letter in the mail from one of these child support agencies. You are hereby notified that an administrative hearing to determine the amount of child support and the method of payment of child support has been scheduled. They're telling you they're going to establish child support and they're going to use income withholding orders to seize your property. Okay, so injunctions. This is going to be a future action that hasn't been taken yet. So injunctions are perfect for this. Okay, so stand by. Okay, so in the mail you've received a notification that you are to appear for an administrative hearing to establish a support order, to establish paternity, establish income withholding order. We're going to focus on the child support order and the income withholding order, which is how they're going to collect the child support. And many of these administrative agencies are statutory tribunals. Some states, they use the administrative hearing through the support agency, and some states use the courts. We're going to deal specifically with the administrative end here by the agencies. Okay, so when you receive that in the mail, they're telling you what they're going to do. So they're basically informing you. Now you have to take action against these future acts. Okay, so we have injunctions to restrain and prevent future acts that have not yet been taken by the state child support agency or the court. They're a state child support agency or the court, they're statutory tribunals, and I'll touch on that in a little bit. To prevent them from committing irreparable harm. Irreparable harm is an essential factor you need to articulate to invoke an injunction. So, how courts define injunctive relief. Whether interlocutory, temporary, or final, injunctive relief is ordinarily preventive or protective in character and restrains actions that have not yet been taken. It is generally not intended to redress or punish for past wrongs. Okay, again, they're for actions that have not yet been taken. So you would not use an injunction against an income withholding order that has already been established and being utilized against you. You would use something else. And I'll touch on that in the next video. To obtain injunctive relief based on past injury, the plaintiff must show a real or immediate threat that the injury will continue or be repeated. So, again, you could use an injunction for that, but I would not use it for that. Accordingly, rights already lost and wrongs already perpetrated ordinarily cannot be corrected, by an injunction. Now, this is Ohio jurisprudence, but this statement is a jurisprudence that every state follows. Okay, so just because I've cited Ohio, I'm giving you a definition. I'm just citing Ohio because it best defines what an injunction is. Okay. So again, what happens when you receive a notice to establish a child support order from a state child support agency or a court? depending on your state? Well, the answer is when you receive notice from a state child support agency or a court, you are being informed that they intend to establish a child support order through an expedited legal process. So they're giving you due process. So now it's up to you to use the courts to protect your rights. So they're telling you, they're giving you their playbook. Okay, so again, this expedited legal process involves the taking of your private property by having a hearing and establishing a child support order and collection of child support using an administrative income withholding order. So when they establish a child support order, they're not going to say, all right, well, you know what, just mail us a check once a month. No, they're going to immediately initiate an administrative income withholding order. And they're going to go right for your wages if you're working and the other. But we're going to focus on the income withholding for your wages. Okay. What do the courts consider private property? Well, as far as we're concerned right now, an interest in a contract is private property and has the same attributes as other property. Again, this is Ohio jurisprudence. And again, this is jurisprudence, so basically every state follows the same. They may not word it this way, but they follow the same definition. Okay, so now, who do you have a contract with? Well, you have a contract with your employer. So when you're employed by your employer, it's a contract. You're going to perform labor for your employer, and in exchange for the labor, you're going to receive wages, which is money, your private property. That is the whole agreement. Now, when these child support agencies send these administrative income withholding orders to them, what they're doing is they're bypassing and they're interfering in this contract. Okay, so that's what we're going to look for an injunction for. Okay, so again, this is another definition. What do the courts consider private property? The phrase property rights, as used in the cases, is understood to include not only tangible property, physical property, but also a contract rights and civil rights of a pecuniary nature, money. Injunction is a proper remedy to protect property rights and interests of every description, whether real or personal, and whether tangible or intangible. For example, rights built on franchises, licenses, trademarks, trade names, and trade secrets may all be protected by injunction. Because when you have a trademark or a franchise, you can gain property through money. Additionally, the right of a person to pursue a business, calling, or profession is a property right that will be guarded in equity by injunction in the same manner as every other property right. And again, I'm citing Ohio jurisprudence. And I'm doing that because I recently helped somebody in Ohio. That's the reason why. But again, I've been doing this for a while. They all follow the same definitions. Okay? So, this is a Supreme Court case, Coppage versus State of Kansas, where the Justice, Mr. Pitney, said, included in the right of personal liberty and the right of private property, partaking of the nature of each, is the right to make contracts for the acquisition of property. Chief among such contracts is that of personal employment, by which labor and other services are exchanged for money or other forms of property. If this right be struck down or arbitrarily interfered with, right, by an income withholding order, maybe, there is a substantial impairment of liberty in the long-established constitutional sense. So they view it as a constitutional right for you to have a contract, your right to contract with your employer. In exchange for labor, you receive money, which is property. And what can you do with money? You could purchase property. You could buy food. You can pay rent. Okay? So if they issue an income withholding order and they start withholding a large percentage of your wages, that's going to cause irreparable harm. What if you can't pay your rent? Right? You could be homeless. That's harm. The right is essentially as essential to the laborer as to the capitalist, to the poor as to the rich. For the vast majority of persons have no other honest way to begin to acquire property save by working for money. So let's understand what these administrative courts are. Okay, so as I'm pointing out here, they're not courts. So that means you can't use a special appearance. Just giving you a heads up. Okay, a lot of people, they try to use special appearance in every hearing. You can't do that. You got to do it in your first hearing, and you have to demand in writing the court's definition of a person. I covered it in the last video. Okay, there are many definitions of person. A person is a legal entity. So technically the court has jurisdiction over specific legal entities. Okay, but again, you can't use a special appearance in an administrative court. Administrative hearings, they like to portray themselves as courts, but let's understand what they are. So again, when you receive notice from a child support agency to participate in a hearing, you need to understand the following important facts. Administrative agencies are not courts. They are not part of the judicial system, nor are they judicial bodies or tribunals. Administrative agencies have no general judicial powers. I don't have it available to me right now, but they also have no contempt power because they're not a court. Okay, so, and again, I just put up this, where is it? Right here. Although administrative bodies may hear and determine facts in this respect, perform duties judicial, and that they are not courts. Again, they want to bring you in there to try and lock you into facts. And a lot of times people walk in there and they just blabber away and they give way to everything instead of just staying quiet or not going, which is an option. But again, you have to do it the right way. This is American Jurisprudence, Administrative Law, Section 23, Administrative Agencies as judicial bodies or courts. And again, now they could be statutory tribunals under a state statute, but again, they have no general judicial powers, and they are not courts as we understand them, courts of justice. Okay, their sole purpose is to establish child support or collect arrearages, determine paternity. Okay. When should you consider filing an injunction? Well, you receive notice in the mail from a state child support enforcement agency, a statutory tribunal, stating their intention for you to appear at an administrative hearing to establish child support. They're telling you. They will tell you in the letter. They also want to lock you into a story, as I just said. Or you receive a summons to appear in court. Now, these courts are also statutory tribunals, and I'll show you, for a hearing to establish child support. Okay? What you should consider after you have received a notice to participate in the establishment of child support. I didn't finish that. But understand how process works. So when they send it through the mail, a letter to you, if you do not mail it back unsealed, they have the right to presume you received it. Okay, so understand that. When they mail it in the mail, and whether it came to you or not, they have the right to assume you received it. So a lot of people are not looking for these things. So they get it, and what do? They open it up. Well, once you open the envelope, you can't really put it back in the envelope and tape it up and send it back. Okay? So, like when I get in the mail myself, like where I live in New York, we have these stupid cameras. I receive in the mail from these agencies telling me, I went to a red light or whatever. You know what I do? I know what it looks like. I just mail it back to them. That's what I do. Because, again, they're allowed to presume that I received it. Well, I'm showing them I didn't receive it. I don't know who it is. And I also write no such person because my name is spelled in all capital letters, that whole thing. But anyway, so yes, I have affidavits just for this scenario. Just send me an email. They're in the description. And real quickly, I know I do not use ChatGPT to write my paperwork. I write them from my brain and from my research. Okay, ChatGPT only has access to public records. There are a lot of information that are copyrighted that they don't have access to. Okay, so just consider that. And also these courts, they realize they know what a ChatGPT letter looks like now. Okay, something to consider. I know a lot of people think they can use ChatGPT now to just put together some type of affidavit. They know what to look for. That's all I'm saying. I don't trust ChatGPT. Again, it's free for the most part. I don't trust anything that's free. Okay, so again, you're going to send them an affidavit. You're going to send it through registered mail receipt as evidence that the child support agency or court statutory received notice of your terms. So again, you want proof that that they received your affidavit. Your affidavit is evidence, and in the affidavit, you're stating things, and you're expecting them to respond to certain questions to provide you evidence. And if they cannot provide you evidence or they do not respond, okay, silence is considered, if they're quiet, that means they agree. Okay, it's acquiescence. So if they can't provide the evidence, they don't have it. Now, in this affidavit, you're going to state certain things, and you're going to expect them to send you evidence. Now, I'm not going to give away the game here, because that's my value. Okay? So, and again, this is the basis for filing an injunction. You sent them a letter, they didn't respond. Well, now that's the basis for your injunction as well. Yes, I can write injunctions. I'm very good at it. Okay, so I'm going to give you examples of what statutory tribunals are. All right, this is California. Okay, Family Code 5700.103. State tribunal and state enforcement agent. Now, every state, it's basically written the same way, except they use different courts and different agencies. So I'm going to give you 3 examples. This is the first one, California. Okay, the Superior Court is the tribunal of this state. So usually every state, they have a court or they have a child support service, a state child support services agency. They all go by different names, but they're going to tell you what the names are, and I'm going to show you. Okay, so you got A, Superior Court. B is the Department of Child Support Services in California. Okay, here we are. I'm going to use Florida. Under Chapter 88, 88.1021, State Tribunal, Child Support Agency. The Circuit Court or other appropriate court, administrative agency, quasi-judicial entity, or combination is the tribunal of this state. The Department of Revenue is the support enforcement agency of the state. Many times you receive letters from this agency right here in Florida. Many of the cases are in circuit court, in my experience, but they're statutory tribunals. A tribunal and a court are synonymously the same thing. And here again, because I just helped somebody with Ohio, under the Ohio Revised Code, Title 31, Domestic Relations, Children, for the purpose of carrying out the duties and responsibility under the juvenile court or the division of the Court of Common Pleas. Those are the tribunal. Okay, I'm not going to read the whole thing. And the agencies designated, hold on a second, right here. It's usually the Ohio Job and Family Services. Okay. But again, they under these codes, they're going to tell you who the tribunals are. Okay. And these tribunals, their sole function is to establish paternity, establish support, collect arrearages. Okay. That's all they're created for. They were created by the legislature. Okay. And that's basically it. So when you received a letter from these people, they're telling you what they're going to do. And the best thing to do is to stop them, to restrain them before it starts. Because many times they initiate the child support and the income withholding order before they've established any facts. You have to fight and prove there are no established facts. Also, again, you have a constitutional right to your property. No revised code or statute can take away your property unless you've violated or caused somebody injury. A lot of these statutes, revised codes, and such, they're procedural. It's already presumed that you have to pay child support. It's already presumed that you're an obligor. It's already presumed that you're a legal entity person. These are the things we're going to question. Okay. All right. So once they send you this notice, the process starts, and they're giving you a warning what they're going to do. The effective thing to do is to go to court and file an injunction against them. And the way you do it is you're going to notify them, you're going to send them an affidavit, you're going to state your terms, you're going to make a few demands, and if they don't respond in the allotted time, you take the registered mail receipt, you take the affidavit, you attach it to your filing, and you apply for an injunction. Just reach out to me and I can help you if you're in this situation. Okay, so again, there we go. Okay. All right, there I go with my thumbnail. All right, guys, I'll talk to you soon. Bye.